The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The Spring Meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law Section. My name is Anora Wang. Today, we're bringing to you a special episode that captures some of the highlights of a panel that we organized in December 2024 titled Antitrust Issues Involving Cloud Computing and Infrastructure, A Global Perspective, co-moderated by myself and Koren Wong-Ervin. So first we have, for speakers, we have Gustavo Augusto Lima, who is a commissioner at the Tribunal of the Brazilian Antitrust Authority, CADE. Gustavo has a long career with more than 20 years of experience in public service and has served in his current position since December 2022. And then next, we have Alexis Pirchio, if I'm not butchering that name, is the president of CNDC, that is the Argentina's competition authority. Alexis is an economist by training, and he was appointed to his current position in January 2024, and he has previously served at the CNDC as a director of anti-competitive practices between 2017 and 2018. Next, we have Agostinho, who is the Deputy Assistant Director of the U.S. Federal Trade Commission's Technology Enforcement Division. Howder has been at the FTC for more than 10 years. And then last, but certainly not the least, we have Thomas DeMatteo, who is the General Counsel for the Senate Judiciary Committee. Previously, Tom has served as the counsel to the Assistant Attorney General of the U.S. Department of Justice's Antitrust Division. We certainly have a panel filled with stars, but I'll turn it over to Koren for the first substantive question.
Wonderful. Good afternoon or good evening, wherever you are. Hello, everyone. Thanks for joining our panel. So I'm going to start with Helder because the FTC has done a lot of really terrific work in the area of cloud licensing and related or other business practices. For example, studying the issues through information requests and holding a panel of experts. Helder, it'd be really helpful if you just walk us through some of this work and some of the key takeaways.
Thanks, Koren. And I'll give the standard disclaimer, but I think it's particularly important during this time of transition in the government that anything I say today just reflects my own views and doesn't reflect the view of the Federal Trade Commission, any commissioner, or anyone else here with the FTC. So yeah, let me just jump into the work the FTC did on the cloud RFI. So we launched the RFI into the business practices of cloud services providers last year, March 22nd, 2023. And the RFI focused on issues related to market power and competition, but also security and single points of failure within cloud computing. In addition to the RFI, the FTC also hosted a public panel of experts on cloud computing, which took place on May 11th, 2023. The panel discussed many of the same issues flagged in the cloud RFI and also highlighted the importance of the relationship between AI and cloud computing, which I know we'll discuss a bit later. The FTC received over 100 comments during the 3-month comment period in response to the RFI. Some of the themes we'll be discussing today were highlighted in a blog post on the FTC's technology blog. That blog post is dated November 16th, 2023. It's available to anyone who wants to look it up, and I'd recommend that as a resource if you're interested in further reviewing what we're going to speak about today. So as I said before, competition was one of the major themes of the RFI submissions. A number of the comments the FTC received suggested that various services within the cloud stack have only a limited number of suppliers, and many of the comments raised concerns that certain practices could hamper competition. I just want to briefly highlight a few of the most common concerns we heard in the RFI responses. So first, some submissions raise concerns that certain software licensing practices of cloud providers could limit the ability of customers to use software in rival cloud environments, thereby inhibiting cloud competition. Some of the comments in response to the RFI suggested that the existence of these software licensing practices was of particular concern when a company was moving from on-premise, moving existing workloads from on-premise to the cloud. A second major theme in the RFI responses was about egress fees. A number of commenters raised concerns about egress fees, which are fees charged by cloud providers to move or transfer data out of a cloud. Some of the concerns raised included that egress fees could discourage the use of multiple cloud providers or discourage switching from one provider to another. And a third main competition-related theme that was raised by the comments was about minimum spend contracts or similar contractual structures. And the comments suggested that minimum spend could lead to lock-in and consolidation of cloud spend with a single provider. For example, a minimum spend contract typically involves a cloud provider discounting its services in return for an agreed-upon amount of spend. Some of the comments argued that these types of provisions could act as a lock-in mechanism, pushing customers to use just one cloud provider for all services the customer needs, even if other providers might offer superior services in certain areas. So those were the three main competition themes that were raised by the responses to the FTC's cloud RFI. Just want to touch really briefly on a few other points that were raised in the responses. One of them was about single points of failure, and this can be considered a competition issue. A number of the submissions that we received in the cloud RFI raised concerns about widespread reliance on a small number of cloud providers. And some of these comments argued that outages or other issues that degrade the service of a cloud provider could have a cascading effect on the economy. I think we have seen some of these in real life. Maybe many of us have experienced the consequences of this. Related, there were several submissions about security, suggesting that although cloud can provide a higher baseline level of security than certain on-premises options, other commenters argued that there's room for improvement in cloud security and that the shared responsibility model for cloud security lacks clarity, which can lead to situations where neither the cloud provider nor the cloud customer implements necessary safeguards. So confusion around who has the responsibility for security, the cloud provider or the customer. And then a final main theme that I wanted to highlight from the RFI responses is about generative AI and cloud. And I know we're gonna get to this later in the program. Just say really briefly, some commenters in response to the cloud RFI noted that generative AI products rely on cloud providers, cloud compute as an input. And so the panel is going to explore the relationship between competition in cloud computing and generative AI. And that's sort of a quick summary of months of work for the cloud RFI.
Thank you. That's very helpful. So of the three main themes you mentioned, I think the second two are kind of self-explanatory. People would understand what they are. The first one, in terms of software licensing practices, are there any specific examples you can give? Not asking you to mention companies, but just did the concerns and the comments give a flavor of what those licensing practices are?
Yeah, so I think just to quickly summarize from some of the comments, concern that restrictions on licensing of certain software products could make it more expensive or impossible to move certain workloads either from on-premise to a competing cloud provider or create some kind of friction between a smooth movement of workloads from on-premises to cloud.
Great, that's helpful. Alexis, I'd like to turn to you. Are you hearing similar concerns or themes in Argentina or in Latin America more broadly?
So the agency in Argentina has not yet received any complaints regarding cloud services. Globally, of course, there's an increasing migration to digital environments, which include cloud services, replacing information processing and data storage infrastructure, both at home and in enterprises and in institutional environments, due to the benefits this generates in terms of flexibility, scale, cost reduction, among other advantages. This migration seems to be slower in Argentina than in other countries in the world, and even compared to other countries in Latin America. For example, right now, Brazil and Mexico are the largest cloud markets in Latin America, also leading in cloud services with 45% and 23% of the market share, respectively. They are followed by Colombia and Chile with 8% and 6% respectively. And after them, Argentina ranks fifth with only 5% of market share. However, the site specialized in digital transformation issues, Innovación Digital 360, recently published a report on cloud services in Argentina, indicated that approximately 35% of investment in information technology in the coming years will come from cloud services. And this is still lower than in the rest of Latin America, but they expect a 30% annual growth, reaching $30 billion by 2025.
Great. Thank you. Tom, I'll turn it over to you. Any thoughts on what has been said so far?
Thanks, Koren, and thanks, Anora. Thanks very much for having me. I really appreciate it. First, I'll just give you my disclaimer that my comments today are my own, and they do not represent any member of the U.S. Senate or the Judiciary Committee or any member of Congress. I think one of the things that has brought attention to cloud computing and the FTC has been this leak to Bloomberg that is a recent article that was published that discusses the FTC looking into Microsoft. I would like to note that it's concerning that this is another instance of leak from the FTC to the press about ongoing investigations. Anytime you're to build a case, having spent a decade at DOJ, myself, leaks undermine the ability of people having belief in the institution of being able to bring the proper enforcement case, because third parties get concerned that their information that they're sharing with the agencies will be undermined. So hopefully this pattern of leaks will end. I know this is not the first instance. So in terms of regarding cloud computing and some of the things that Helder has outlined, I think it's important to consider, who are the incumbent players in this area and how they can use whether it's being vertically integrated or bundling and tying to help their current market structure and then sometimes market shares to gain benefits in other areas, contracting, to create either an incentive to box out competitors, smaller competitors, and perhaps sometimes even more innovative competitors in other areas, and locking in customers into a vertically integrated stack where that prevents competition down the road, in the sense of what traditionally called a walled garden. Those can be concerning because then it not only forecloses competition for front end, but then it also forecloses future competition.
Thank you for that. And let's focus a little bit more on one of the specific aspects that has been mentioned by one of the experts from the FTC's workshop. And that particular expert was OECD Chairman Fred Jenney, who discussed an independent study that he conducted in which he concluded that unfair software license terms enforced by certain legacy software companies risk significant harm to competition in cloud, damaging growth, innovation, and viability of cloud infrastructure providers. I will walk through that several things that was mentioned, But particularly in this study, Professor Jenny identified a number of what he described as concerning yet typical license terms. This include first, bundling and tying software products with cloud infrastructure to make other cloud providers' offerings less attractive or more expensive. I think, Tom, you just mentioned that. And then the second area that was identified by Professor Jenny was increasing prices for those business partners who are using their own cloud infrastructure, whilst keeping the prices unchanged for partners selling on the software provider's cloud infrastructure. And then the third aspect that has been identified is artificially limiting data portability to make it expensive, if not impossible, to use competing cloud infrastructure. And then the fourth aspect that has been identified is the removal of bring your own license, BYOL, deals, meaning customers are forced to pay again to use software they already own on competing cloud infrastructure. Certainly there is a lot to unpack, and but I expect to hear some reaction at least to some of those. So I'll start with perhaps with Alexis first. As economists, what should the proper economic analysis or framework be when approaching these issues?
Sure. So regarding the first practice, I would say that antitrust law in Argentina classifies tying and bundling as practices that restrict competition and is punishable as an abuse of dominant position. In other words, the authority must prove that the company that carries out such practice has a dominant position in at least one of the markets first, then prove the commission of such practice. This is also valid for the markets we are discussing. For example, it could be an anti-competitive practice if a company with a dominant position in software and a minor share in cloud services requires the customer to purchase cloud services in conjunction with software services. Then in terms of limiting portability, this is the type of practice that has been regulated in other markets in the past. For example, mobile telephony. Today, in digital environments, we see more and more jurisdictions requiring portability and interoperability from service providers, such as cloud service providers. However, this type of intervention by competition authorities is more common in jurisdictions that have ex-ante regulation. In Argentina, a recent example of regulation on interoperability is that proposed by the Central Bank of Argentina regarding QRs for digital wallet payments, so that the same QR can be used by the different digital payment providers that exist. But there is not such a regulation for cloud service infrastructure so far. Then for price discrimination and removal of BYOL, this could also be considered as an anti-competitive conduct, but they would merit a more case-by-case approach. Thank you.
This is very helpful, and maybe this is a time for us to turn to how, since this has been discussed at the FTC workshop, I imagine you have some responses to this. Would you add anything? What do you have seeing as an enforcer about these practices, and what your concerns are?
I don't really have a lot to add. I do just want to say that, in certain circumstances, we the inquiry into whether there's legality from tying and bundling and some of these other practices discussed is going to be very fact specific, and that's what any determination in the U.S. will be guided by.
That's very helpful. Tom, do you have anything to add on this particular issue?
I think it's important if, Alexis kind of mentioned regulation of this forced data portability of not being currently present in cloud computing, but it is present in some other areas. In the U.S., I'm not aware of any regulation that would require that. Certainly, I think this is probably best addressed through an enforcement posture than regulatory.
Next, we have Gustavo joining in time. Would you tell us about your concern as a competition enforcer with these types of practices?
I'm quite happy in fulfilling this position and speaking from CADE. I'm one of the commissioners of our tribunal. I'm actually the most senior commissioner, so usually this is why I substitute our president in this kind of situations. Well, regarding the report made by Mr. Frederic Genie, it was a quite interesting one. And first of all, I want to clarify that I'm not going to speak about any concrete recent investigations that we have, because as one of the commissioners, I may be part of the judgment of the case. So I'll try to focus in cases that are already closed and not in ongoing investigations. We do have, and probably some of you have heard about, we do have some recent investigations, digital platforms, especially regarding Google and Apple. I'm sorry to say we're not going to discuss that today, but what I can say is that signing and bundling are actually economical offenses in CADE legislation. They, of course, goes by the rule of reason, so they are not per se infringements. And so this is why that's one of the main reasons so difficult that we have those cases. It's very uncommon in CADE to issue a conviction regarding tying or bundling. Not only in licensing software, but in the general market. For that kind of offense, we would require strong economical evidence. That's probably it's exclusionary practice. Recently, that's a ruling still open. We have a very big discussion regarding bundling and tying in our tribunal. That's not from digital platforms, that actually for means of payment regarding credit cards and credit cards operation in bank institutions. And one of the things that CADE usually looks at cases like that is the economical evidence. Of course, we are aware of tests like Lepage. This is something that we may approach during our votes, but I don't think CADE would issue a vote basically solely on Lepage. In my recent vote, which was in the Itaú case, I actually considered the discount attribution test following the Ninth Circuit's theory, but this was one of the aspects of the operation. So usually it would be evidence-based and economical-based. We have a different rule in Brazil because CADE does not apply the consumer law, the consumer legislation. So we have different bodies for that. Before consumer legislation, it's also offense. It would be a different one. And the standard to prove that would be lower. So I would say that an antitrust violation regarding bundling or tying, it would demand very high evidence that this practice is exclusionary or could damage the consumer welfare standard. But before the consumer legislation, this would be closer to per se. So the presumptions in favor of consumers in Brazil are very high, and usually the penalty are lower before consumer legislation. The consequence for the company for violating consumer legislation would normally be not so strong as antitrust legislation, but the standard of proof is lower as well. So I'm not sure if I cover everything. If you want to maybe recap something, or we can just move on, and my next iteration can detail something. Oh, actually, there is one case I would like to mention, which would be Xerox. Well, Xerox had cases like that all over the jurisdictions, but we had our own Xerox versus Repro. This was exactly tying and licensing. This specific case, it was from the 90s. So this is probably shows these cases are very uncommon in our jurisdiction. And sorry, this was for exclusivity cases, and this type of case, it's more common in our jurisdiction, meaning when you have someone with a very high market power that not only does tying and bundling, it actually demands exclusive deals. So we had a few cases in Brazil, not only Xerox, but Xerox is probably one of the most famous. Bundling cases, usually CADE sees them as beneficial to consumers because usually bundling will decrease prices. So unless we're talking about predatory conduct or something that's really exclusionary, it's very rare that we would have a conviction. But when you use time bundling associated with exclusive deals, this could be exclusionary. So in that case, you could be creating barriers to entry. And this is the kind of case that would hold up if we had the evidence to support it. And we actually had a few. We have one it's a digital platform from gymnastics, which is GymPass. GymPass, actually, they changed it. It's GymPass, SmartPass. They actually changed the name of the platform for WellHub. It has some recent developments that I can't comment right now, but in that case, we have limited exclusive deals. CADE, it's very difficult that CADE currently forbids altogether exclusive deals, but usually what we try to do is limit the number of exclusive deals, so this cannot be an entry of barrier. This specific case was digital platforms involving gymnastics and that kind of club, and associations with, you could basically do a signature in this digital platform and have access to multiple gyms and multiple clubs. So in that case, what we demanded is that you could not have a certain amount of exclusive deals that could exclude other platforms, because of course in a specific city, all the good clubs, all the major clubs assigning one specific digital platform, it's very difficult for a second platform to enter. And this was specifically the case. Right now we are monitoring this agreement. It ended in an agreement with the platform, but of course this agreement is somehow a conviction, even though we haven't stipulated fines for that, but we have stipulated a lot of remedies. Okay.
You.
So I think that sums up for now. And of course, I'm open to discuss it further.
That's very helpful, and it's so good to see you. So it sounds like, the panelists who have talked about sort of traditional antitrust theories of harm, input foreclosure, tying bundling, the kind of traditional analysis. Are there is there anything unique about cloud? And so maybe I'll start with Helder in terms of, did you hear this in the workshop or in the studies? I know, for example, the FTC's done work in labor markets, and there are some kind of unique and special things to take into consideration in labor markets. Do we have that with cloud? Another thing is it perhaps of increased importance, given that cloud computing and infrastructure is in many ways, a critical input into AI development and deployment. And so if we're foreclosing smaller and rival cloud providers and they're not able to grow and offer alternatives to capitalize on AI in the same way, does this have broader impacts in the market? Does it have supply chain impacts that could impact inflation? Does it have labor market impacts? So I guess my question really is there some special characteristics about cloud that we should be thinking about?
Fred, I think you hit a lot of them already in your intro, but I think one of the things we've seen from the RFI and from other, just studies of the market that we've done is, to me at least, cloud is kind of an interesting position where, as you said, it's an input into emerging technologies like generative AI, where it's one of the most important the cloud compute itself is one of the most important inputs and is a critical input in developing generative AI, which requires a huge amount of cloud computing power, both to train the models, the frontier models, and also in some instances for inference by the models. And so, I think we should be thinking about generative AI. We should be thinking about other industries or other technologies where cloud is a key input, technologies that require a lot of cloud computing power. But cloud is also in a way sort of in the middle of the stack, and there are some inputs like chips for AI applications and for other high intensity processing applications that are important input to cloud. And so I think it's helpful to think about not just the cloud layer, but any inputs and the competitive dynamics of any inputs into cloud itself. We've seen lots of public reporting about the amount of power it takes to run data centers. Various companies building or having plans to build huge data centers, maybe to bring nuclear power plants back online in order to power them. And so thinking about cloud has made us think about various different parts of the stack, upstream and downstream. And then one last point I wanted to mention is it's also interesting to think about cloud as sort of a distribution platform for generative AI models, but for many other things too, and to be thinking through the competitive implications of having a distributor who may have competing products that's also distributing generative AI and also in other spaces. So cloud is certainly a very key component of almost every technology now that requires significant networking and compute power. So I think it's helpful to think about it holistically.
That's really helpful and very interesting. Any other panelists want to jump in on this?
Well, try. Oh,
yeah, Tom.
Thanks. I think all great points there. I think it's interesting when you look at cloud from the perspective of customers. This cloud computing is not a commodity market, so each customer has different needs. Whether it's a hybrid solution with traditional data storage or a full cloud storage, and what those implications are in terms of data security. Certainly in private companies are going to have different needs as a consumer than the U.S. government might have, for example, with DoD. So, it's important that in order to provide the best competitive solutions for every customer, that the cloud computing providers are innovative, and they don't keep perhaps smaller competitors at bay by using some of the market advantages that they may have from being large tech companies in certain product offerings to keep smaller companies out from bidding.
Yeah. Commissioner Augusto?
Okay. Thank you. First of all, when you analyze cloud structures, you cannot only think about the infrastructure by itself. It's not just hardware, because it involves data as well. So if you're providing cloud services for a certain company, not only you, of course, have a very strategic part of the business inside their structure, you also has a lot of data of how their company work, how the software work. So of course, there are a lot of advantages that providing cloud services that's associated. That's not only hardware. Considering that, I don't think CADE right now is in the position to say it would be essential facility. It's of course a very important facility, and of course it could open up all types of antitrust misbehavior. But for us to say it is an essential facility, we would need to demonstrate that it cannot be replicated by the other contestants. So of course it could be the case, and probably artificial intelligence could be the case. But as far as we have different companies providing that, as far as it's possible to have entry, I don't think we would consider that as essential facility. Probably if we had some kind of acting in the cloud services or artificial intelligence, we would demand a specific misbehavior, not a specific offense that's not only the search is important.
I think that's very helpful. Let's shift the gears a little bit to a third area that we want to, a fourth areas we want to talk about, which is competition enforcers around the world in various jurisdictions have raised concerns about concentrated control of cloud computing as a key input into AI development and deployment. What do you see? I ask each of the panelists, what do you see as the concerns and what should the proper antitrust analysis be? Let's start with Gustavo, if you don't mind.
No, I don't mind at all. Thanks so much. We are getting in a new frontier here, right? We are getting on the cases that are probably hard, that probably we do not have a lot of evidence. And usually it's the best approach to be cautionary when you're entering in that kind of discussion, because of course we do not want to permit that any kind of misbehavior takes place. But on the other hand, if you're doing some overreach, you're probably avoiding innovation. And that's something that we should look into. So far, we didn't receive any reports that show that actual and proven antitrust evidence or antitrust harm is being done in that kind of services. Of course, we all understand that this kind of monitoring is very difficult. It's very complex. We're talking about technological companies that has a lot of resources. The market changes a lot very fast, and it really demands a closer look by our authorities. But we do not have so far found evidence of antitrust harm being done in that kind of services, even though we have very closer look regarding, for instance, Google and browser services.
Alexis, do you mind chiming in on this?
Sure. So as we know, AI development relies heavily on cloud and computing infrastructure, and training AI models also requires large-scale data. Therefore, while there may be innovative AI startups, the reliance on big data resources and cloud services makes it difficult for such companies to have a growth trajectory independent of big tech. This is because, for example, the public cloud space is highly concentrated globally, with just 3 major companies controlling approximately 65% of the entire market. The exponential increase in the cost of training AI models creates a barrier to entry for AI startups, forcing them to cooperate with the big tech companies to gain access to computing infrastructure and end users. This is why we see agreements in which big tech companies fund AI developers in exchange for exclusivity in the use of cloud services, creating highly interdependent relationships between the two technologies. At the same time, big tech companies continue to develop their own AI models that compete with those of the smaller companies they provide cloud services to. While the adoption of AI models in Argentina is still incipient, as are cloud services to some extent, these markets are global in scope, and their increasing interdependence and concentration may have detrimental effects in the country. For example, if as a result of little competition, few competitors, high prices, companies established in Argentina are prevented from adopting such technologies.
I think that's very helpful.
Yeah. Thank you.
Yeah. And then let's turn back to the States for a little bit. Tom, may I ask you to share your views? Do you have any concerns over concentrated control of cloud computing as input into AI development deployment?
I think Alexis made some good points. When I think about cloud computing as an input to AI and the amount of data required, I think for AI to be successful, I see some analogies to search. And we don't want our AI market in the next 5 or 10 years to look like our current search market, and having to bring in antitrust enforcement actions to unwind issues. And we talk about, Alex talked about these agreements with startups or innovators, with big tech companies that essentially help the large platforms. We saw that in search as well. We see contracting around to help build the moat around the large tech players, and the lockdown of data access points to prevent new entrants or new innovation or new developments in order to keep the large players' market position in place. So my hope is that in AI, we don't have to redo the search playbook in order to make it competitive.
Yeah. Howder, may I ask, do you agree or disagree with what Tom just said? Do you have any concern over the same topic we were just discussing?
Yeah, I mean, I guess I'll just kind of say the same thing Tom said. I think Alexis raised a lot of good points. I think even in these innovative markets, the competition analysis could be the same as in other markets. Mentioned, compute as an input to generative AI. And sort of the traditional vertical analysis, I think could apply there. I'm not saying it does. Same for the point Alexis made about some of the companies that are cloud compute giants also may have some of their own generative AI models or work in generative AI. I mean, to the extent they're investing in independent generative AI, is there a horizontal concern there? I'm not saying again that there's anything to investigate there, just that the traditional modes of reviewing vertical or horizontal relationships would apply here. Obviously, there are challenges faced by the amount of data, the amount of information involved in these markets, and the evolution of the markets. But I think the tools we have are applicable to, as long as we put them to work.
Several people have mentioned data as another, sort of critical input. And I'm wondering your reactions to, my understanding that there are a lot of open source models that allow startups to use, right? And to train models on. And I think in terms of, I think ChatGPT, for example, is sort of a testament to the type of disruption that we're seeing and can see, including from unexpected sources, right? So people have long said that certain so-called big tech companies have all these insurmountable data barriers and network effect barriers and others. But then here comes ChatGPT. So any reactions?
I think that's an interesting observation. I don't know how long ChatGPT continues the way it is, and will it get bought up by a different technology company, as technology companies roll out competing ChatGPT offerings, will they be preloaded onto your devices? Will they be somehow given advantages over a non-affiliated type of offering like ChatGPT? Will there be ways where ChatGPT can be excluded and given advantages to some of the incumbent players' offerings if they do roll those out?
Thank you all so much for taking the time. It's a very interesting discussion. Thank you to our audience for joining, and for other ABA programs. They're listed on the website or through the listservs. All right. Thank you, everyone. Have a good rest of your day. And
Thank you.
Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.